welcome to this session on wrongful convictions and actual innocence. Today we're going to talk about the history of wrongful convictions, and we have one of the nation's leading experts with us. Jules Epstein has been working in this field for a very long time. He's been a practicing lawyer for 42 years. He's a law professor. He's done a lot of work on actual innocence cases. He is at Temple University now in Philadelphia. He's someone who has an expertise across the range of issues concerned with wrongful convictions. And today he's going to help us lay a foundation, talk about the history of this subject, why it's important. And without further ado, it's my great pleasure to introduce and welcome to you, Jules Epstein.
All right, thank you so much, and hello everyone, and I'm so honored that you're attending this program. So as you heard, I'm going to give a little historic background of this subject. And the history of worrying about wrongful convictions is a long one. Take a look at this quote. Sir William Blackstone was a scholar on the law hundreds of years ago. And his famous quote is, "It is better that 10 guilty people escape than that one innocent suffer." That's why in this country we demand proof beyond a reasonable doubt. It's not a perfect protection. But the theory behind it is, even if sometimes a guilty person gets away, boy, do we want to avoid an innocent person going to jail. This has been an issue for hundreds of years in different areas of the law. The picture on the right has the words corpus delicti. And in England, hundreds of years ago, they actually developed a rule. They called it the corpus delicti rule. And it said, before we will accept a confession in court, we want real proof that somebody died. Because as you see on the left-hand side, there's a story. In a case called Perry's case, Perry confessed. Okay? He was executed, and then the victim showed up, which is not a good thing. And so that was really a recognition of two things. One is that sometimes people can confess when there was really no crime. And the other was, we want to be careful to avoid the risk of wrongful convictions. Let me stay with England as we study this history. A lot of our law came from England. We have some shared experiences with England. There's a lot there. So this was a man named Adolf Beck. Adolf Beck, there's actually a book called The Strange Story of Adolf Beck. You can Google or whatever web search you like and look up Mr. Beck. Mr. Beck was identified by a whole bunch of people as a man who had committed fraud. He went to jail. He got out. Fraud started again. They arrested him again. But guess what? The fraud kept happening. And they finally caught the real person. It was so shocking in England that the English Parliament looked into this and had a commission to say, how can it be that so many eyewitnesses were wrong? Well, that was on the other side of the ocean. Let's come to our side. A small footnote in American history is a man named Edwin Borchardt. And over 100 years ago, he wrote a study called Convicting the Innocent. It was about whether people should get compensated by the government if they were wrongly convicted. But a large part of his book was writing about cases in the 1800s and early 1900s, where it was proved people in this country were wrongly convicted. Here's one of those cases. And actually, these are numbers from it. He studied a total of 65 wrongly convicted people. 44 of them were cases of mistaken identification. If you're good at math, you'll know that's roughly 2/3. Well, guess what? Today, in wrongful conviction cases where people have later been freed by DNA, something we'll talk about, it's roughly 2/3 involved mistaken identification. So that's why I call it a chronic problem, a problem that's been there for a long time. Okay. Other people started to pick up on this. Felix Frankfurter in the 1920s was a law professor, and he ended up getting very concerned about mistaken identification because there was a famous case in the United States of two radical activists named Sacco and Vanzetti who were convicted of a crime, and Felix Frankfurter wrote a whole book about it and really raised questions about the mistakes eyewitnesses make. Later on the United States Supreme Court, he wrote about that. So there are little blips of awareness, but this is a problem that has been here with us for a long time. The concern about wrongful convictions even found its way into the United States Supreme Court. And it found its way into two categories of cases. Cases about, you ready for this? False confession. And cases about mistaken identification. It's a very sad part of American history, but especially in the South, although not limited to the South. Police, sheriffs, law enforcement tortured people to get confessions. And between 1930 and 1950 or 60, a whole bunch of those cases went to the United States Supreme Court. Here's a description from two of them, and they're really shocking. They hanged him by a rope, and then they hung him again, and then they whipped him, Brown versus Mississippi. And in a later case, 1944, right? Sure, I'll confess, the court wrote. People will confess to avoid physical suffering. In other words, the court was saying torture doesn't give us accurate confessions, it gives us wrong confessions. So again, it wasn't the awareness of wrongful convictions that we have today, but one by one, these issues were coming up in American history. It made it into the popular press. This was a case from the East Coast. A priest was charged as a bandit in a whole bunch of cases. Okay? And then all of a sudden, somebody else confessed, and the priest was let go. But he was the one who people identified as being the bank robber. A quite famous case in its time. It came up in the 1990s, or late 80s and early 90s, in a different area. And that was the area of claims of child abuse in preschools. And there was a very famous case called the McMartin School. That was the name of the school, where children were somehow prompted into saying that the people at the school were Satan worshipers and did all terrible things to them. Lots of people got arrested. After a while, it was realized that, it was a bad investigation, and this was a product of suggestivity to the children. So again, a concern about mistakes in court cases, but each of these was like one little drop in a bucket. Here's when it changed. DNA came along, and starting in, I guess, the late 1980s or early 1990s, started proving people were actually innocent. And after the first 28 such cases, and I give her great credit for this, the United States Attorney General, who's the chief prosecutor, the person whose job it is to put people in jail, said, we need to study what went wrong. And anyone who wants could go online and look this up and download this for free. Convicted by juries, exonerated by science, the science of DNA. So what did we learn? This was the book about the first 28. The woman in the lower right-hand corner is the first woman Attorney General of the United States, the Honorable Janet Reno. And she said, I'm here to prosecute people, but I want to prosecute the right people, and we need to see what is going wrong. And she put together a blue ribbon panel to look into this and try and figure out what actually went wrong. And it really started people realizing it's not just one case at a time. There are some real problems in our system of criminal justice. So these two guys are much younger. They're a little older today. On the right is Barry Scheck. On the left is Peter Neufeld. They were part of that Blue Ribbon Commission, and they formed something called the Innocence Project. And they started finding cases around the country where people were convicted, but there was still evidence that would have blood on it or bodily fluids, and they get it tested for DNA, and lo and behold, the wrong person was in jail. And as they got people out, they started saying, what went wrong? And you can see from this chart, lots of those cases had eyewitnesses, not people who were lying, but people who were sincere but made a mistake. Some had bad science. Some had false confessions, like way back in the Corpus Delicti. Some had dishonest informants, people who themselves were criminals and were trying to cut a deal. And then the public awareness grew. On the left is a gentleman I'm honored to be able to call a friend, Kirk Bloodsworth. Kirk was the first person sentenced to death who was exonerated by DNA. His case involved mistaken identification. If you're ever going to read a book, his biography is an incredible story. So too is the book on the right called Picking Cotton. The woman you see there is named Jennifer Thompson, now Jennifer Thompson Canino. When she was a college student, a man broke into her apartment and raped her. She picked a man named Ronald Cotton. 14 or 15 years later, DNA showed she picked the wrong person. This is a remarkable story of human nature and kindness. They became best friends. They advocate for steps to improve the criminal justice system, and they wrote a book that tells their story. So with stories like Kirk Bloodsworth and Picking Cotton out there, people really began to realize how serious this problem might be. A great law professor named Brandon Garrett did a study of the first 200 cases where DNA showed, whoops, we got the wrong person. Look at those numbers. A high number, almost 80%, involved eyewitnesses. A lot of them were from the victims. Can you imagine? And it's a horrible thing to think about. In a rape case, the victim's face and the perpetrator's face are often quite close to one another. There were mistakes after mistakes. And sometimes people said, oh yeah, that's so-and-so, because they were friends with so-and-so, but they saw a picture in the newspaper of the suspect, but they were wrong. They picked someone who they thought looked like the doer. DNA showed they were wrong. Today, these are some data from the National Innocence Project. We see 1989, the first DNA exoneration. The National Innocence Project, located in New York, as of today, because I looked them up, lists 375 cases where DNA has exonerated people. Look how how old they were. They went to jail when they were 26. They got out when they were 43. And some of them actually pled guilty. And you might say, why? Because they were scared and because a guilty plea meant their punishment might be less than if they went to trial. So in other words, we have had innocent people plead guilty. So the Innocence Project says 375. There's another very important organization called the National Registry of Exonerations. By their count, they have a record of over 500 DNA exonerations and lots of exonerations from other reasons. So there have been a lot of exonerations and a lot of study of this problem. Here are some facts about who these people were. 60% African American. And look at the data point on the right. That if you are a black person charged with killing a white person, the risk of a wrongful conviction goes up. So some scary things about the reality of criminal justice in our country, which tries to do a great job, but clearly can't always get it right. There are more causes. We're now learning more causes. Sadly, we've had labs where, like drug labs, where the chemists have falsified reports or had other kinds of problems. We've had police falsifying evidence. Not often, but it happens. And sadly, and my background, you heard, is as a lawyer who's represented people. Sometimes people are wrongfully convicted because they just had bad lawyers. Exonerations continue. You can see this is from an organization called the Death Penalty Information Center, that there have been exonerations through the year 2019. And again, lots of reasons: bad lawyers, false confessions, perjury, and of course, mistaken eyewitnesses. So what do you do if you want to learn more? If you type into a search engine the words Innocence Project, you will get linked to the Innocence Project, National Innocence Project. I think every state or close to every state has its own regional one. And you'll get all sorts of information. And separately, there's that organization I talked to you about, the National Registry of Exonerations. And those are the sources of information. So I'm going to leave you with those thoughts. I think Mark is going to rejoin me now. But again, thank you for being interested in this subject. And I will be rejoining you on a later talk when we talk specifically about eyewitness identification. Mark, will you rejoin us?
Jules, this is a world that you've been part of for many years, and it's one that creates a great deal of heartache. Typically, we have a system where people are trying to do the right thing, but we're human, and mistakes are made. Sometimes those mistakes are intentional, and there's no excuse for that. But on other occasions, the mistakes are innocent mistakes, but the result is a wrongful conviction. When you take a look at the justice system, are you heartened by what you see, or are you troubled? When you look at all that's happened in the time leading up to now, where we are and where we're headed, are you optimistic?
Yes, I am optimistic, and I'm going to tell you why. Once we got the leadership from Attorney General Janet Reno, it began a process where slowly, and it's still slow in a lot of states, and it's uneven. You know, different states are good about different things. Texas is a great state in terms of issues like good forensic science. making sure forensics are good. My state isn't. We're catching up on some things, but more and more police departments and prosecutors' offices are doing trainings on this and trying to use better practices. Do we have a long way to go? You bet. I'm also heartened. I teach at a law school where 20 years ago we didn't have a course called wrongful convictions. Now we do. So there are some positive signs, still a lot of work.
When you think about a lot of work that yet to be done, you mentioned in your talk what's happened historically, how we've gotten to where we are. You've now said that there is a lot of work still to do. What is that work? If someone were given the opportunity to wave a magic wand and change the justice system, what are some of the first changes that should be made?
Well, I don't know first because there are so many, but I'll talk about two that are near and dear to my heart. Eyewitness identification is a real problem. And there are really better, if not best practices for police, for prosecutors, for everyone in the system to deal with it. And we're very lucky that we have a lot of research scientists in America who are studying that. But we really need that to filter down to all the police departments and all the investigators. And the other thing is we really need better resourced lawyers. We have overworked public defenders. We have overworked prosecutors who can't dig down and who don't always have the training to dig down. So those are two of many areas, but those were the two that came to my mind immediately.
When you teach a course to your law students and you address the subject of wrongful convictions, what's your goal with them? Are you finding that your students are going out to do prosecution or criminal defense work and in so doing are more cognizant of, more aware of, more concerned about the notion of wrongful convictions?
So some people take that course just because it's a cool course, right? But yes, it's a lot of people interested in criminal justice from both sides, defense and prosecution. And then some people are interested in things like legislation. There's another reason they're taking it. It's a part of law school where you're really studying important stories about human beings, right? We're not fighting over contracts there. We're learning about things that radically affect people's lives. But it is inspiring a generation of lawyers to go on to be the lawyers we want them to be, people concerned about justice and trying to do it right and do it right the first time.
In your conversation, you mentioned that there are times when people confess even though they weren't guilty. And you mentioned that sometimes it's perhaps in their best interest to do so because they will get a shorter sentence. But aren't there also instances where there are false confessions simply because the process of questioning the defendant is so burdensome, is so overwhelming that an innocent person is led to plead guilty?
Yeah, so there's been a lot of study about what we call police interrogation techniques. And often they get the right person, but some techniques have a higher risk of pressuring an innocent person, especially an innocent person with some vulnerabilities, really young, maybe slightly mentally or emotionally impaired and vulnerable, to finally say, I did it, and to accept the story and almost absorb it. So that is a problem.
Our system of justice is one that is, generally speaking, adversarial. We pit the prosecution against the defense in criminal cases, and ideally, truth and justice bubble up as a result. When we're looking at cases of wrongful convictions, though, and we're trying to correct a problem that has happened, or correct a system that is not functioning as effectively as it should, we found that one way to provide an assistance educationally is to bring together all the different elements of the system, defense lawyers, prosecutors, judges, and instead of treating it as an adversarial system, to try to treat it more collegially, where people come together to try to determine what went wrong, what can be done to make systemically the likelihood of wrongful convictions go down. But it seems to be turning on its head, this notion of an adversarial system. How do you account for this?
So it gets adversarial when we're gladiators in the courtroom. But I have to say this carefully. The best thing that ever happened to the wrongful conviction movement was when police officers realized, oh my goodness, I put the wrong guy in jail. And they started talking to one another. And prosecutors said, oh my goodness, I was responsible for putting somebody in jail. We have to figure out better systems. And it was when everybody then started dialoguing, because no one wants that on their conscience. And of course, if you're a prosecutor, you want the right person in jail, because if you put the wrong one in jail, the right one is still out there doing crimes. So this collaborative approach, and it took some work, right? And some sitting down over some, refried beans or whatever we're having at one of those conferences at lunch. It was, at the end of the day, we're all better off if it's done once, done right, and it's the right person. And it's been a remarkable phenomenon to be a part of. Thanks to you folks at the center, I've been able to be a part of some of those discussions. But it really is a place where we're not fighting, and we're saying, right, without making anyone blameworthy, something went wrong here. Anybody have any ideas how to do it better? And that's been a great approach.
It's interesting you mention that because Jules, because one of the things that we've discovered as we put on programs for participants in the criminal justice system, initially there was a lot of skepticism. People weren't sure that the system was broken, or that it wasn't working as effectively or efficiently as it should. And we found that one of the important things was to try to humanize the issue. And we found that the best way to do that was to bring in exonerees, people who had been wrongfully convicted and who spent time in jail for something they didn't do, and have them tell their story, because that puts a human face on the issue. It's not just a statistic. It's a person who has suffered because the system didn't work. And frankly, you've helped us see that that's a way to tell the story in a way that gets people on the same page, that leads to the kind of collegial effort to find solutions rather than just resorting to the traditional adversarial system. So thank you to you for helping us get to where we are. And before we close, I just want to give you an opportunity, if you have any parting shots for our audience. We typically have taught over the years lawyers who are defense lawyers, prosecutors, judges, law enforcement officials, people inside the justice system. And as we've said, this is a chance for us to go beyond that small circle and to reach out to members of the public, students, people who are not part of the justice system. And if you have any closing thoughts that you'd like to offer for this audience that we now have in front of us, please, the floor is yours.
I really just have two. One is to say to anyone who's watching this, thank you. Thank you for having some interest in a problem that we all need to fix. And my second is thank you. Thank you to the Center for American and International Law and the people who are sponsoring this, because this is an educational effort that is critical. And with that, I wish everyone safety and wellness and health. And thanks for letting me be a part of this.
Very generously and well said. Thank you.